Are we live?
I have your YouTube up, but I'm just not positive. Sorry.
That's okay. It's your first day. Hernando, are we live?
Yes, Your Honor.
Okay. All righty. Let's go on the record on cause number Tony, are you there?
Yes, sir.
Let's go on the record on cause number DC 1810023, Maria Morales versus Burke Grillette et al. Counsel, make your appearances.
Your Honor, my name is Laura Rivas, and I'm attorney for the plaintiffs.
Your Honor, I'm Stacy Glenn, attorney for defendant Jenny Watson.
And I am Dana Woods. I am counsel for defendant Grillette.
Okay. Let's go ahead and get started.
Okay, Your Honor, we have two counter affidavits at issue in this hearing. We have one by Dr. Patel, who's an orthopedic surgeon, and one by Ricky Merritt, who is a licensed pharmacist. We moved to strike Dr. Patel's counter affidavit due to his lack of qualifications to opine on pain management treatment and bills. In addition, we moved to strike his counter affidavit due to his lack of notice regarding his opinions on necessity for pain management treatment, and also because his opinions are highly unreliable. They in fact contradict the treatment recommendations that are posted on his own clinic's website. I'll move through Dr. Patel's first, and then we'll move on to Ricky Merritt's, if that's okay with you.
Okay.
Okay. So again, like I mentioned, Dr. Patel is an orthopedic surgeon. He is opining that all of Maria Morales's pain management treatment from this case was unnecessary. As a result, he also states because the treatment was unnecessary that he believes that the bills are unreasonable. We moved to strike because he has no experience from what he's shown us or shown the court as a pain management doctor. I did note in the response from Jenny Watson that she said that the doctors that were treating at Momentum Spine and Joint are the same types of doctors as Dr. Patel, Dr. Choi, Dr. Chan. Those are pain management doctors. They do not perform surgery like Dr. Karkalapudi or Dr. Patel. Also, he gives no basis for, other than his experience and his general background as a doctor, for him opining that the necessity of the treatment was not there. And he states that this is a 31-year-old, young lady that we're talking about, Maria Morales. She had 3.5 millimeter herniations, 2.5 millimeter herniations, actually went through with getting surgery done. And he's saying that she doesn't even need as much as a initial consult with a pain management doctor. He does give some basis for his opinions on the cost, but again, we don't feel like he is qualified to opine on pain management costs. So we moved to strike those as well. And also after a little research online, I checked out his website, checked out his qualifications and whatnot. He makes a lot of recommendations on his website, his clinic's website, regarding treatment for the exact same type of injuries as Maria Morales had, herniations, whiplash, different types of symptoms that he said that you need to go get treatment, as soon as possible with a spine doctor. I've quoted some of that language from the website in my motion on page 9. Just to kind of highlight and underscore the fact that these opinions that he's providing the counter affidavit just for this case specifically in exchange for a paycheck from the defense firms, that they're not even how he practices medicine in his practice outside of this case. For Ricky Merritt, he's not a doctor, but he's a licensed pharmacist. He opines that all of the pharmacy charges in this case were unreasonable. He is very basic, very generalized. I think his counter affidavit was maybe 2 pages long. Again,
let's deal with these one at a time. Let's get to Dr. Patel first.
Okay.
So I can tell Ms. Glenn has been in my court before because they've already seen, we have a new intern today, Ms. Smith, and then Mr. Felix has been with me for a while. So they've already heard me talk about counter affidavits that I require like to like under Turner v. Peril, which is apparently what Dr. Patel is, though we can talk about that.
Okay.
And also I don't, I don't let the counter affidavit doctor use Medicare, Medicaid, workers' comp, or anything like that, because it's not apples to apples. It's a different billing system. But that's not what Dr. Patel did. So it seems like, Ms. Glenn, you kind of fit within my rubric here, but is he really a pain management doctor? I guess is the main issue here. Is he really qualified to counter these particular bills?
Well, Your Honor, the point I was making in the response is that Momentum Spine and Joint is an orthopedic spine clinic. Dr. Patel has an orthopedic spine clinic and a practice. They treat the same areas of the body. And what Dr. Patel did is the same thing that the minimum spine people did, was look at the plaintiff's MRIs and her testing and determine what kind of care she needed. And he determined that she did not need any of the treatment that was provided in Momentum Spine, including the surgery, by the way, which is the biggest portion of that bill. The judges in Turner versus Peril specifically envisioned such a type of a counter affidavit, and stating on page 748 that if Dr. Sibley was controverting Turner's claim based on a denial that he had suffered any injury, then it would have been a simple matter to say as much. Dr. Sibley's affidavits did not give reasonable notice of the basis for his conclusion that none of the medical services were necessary. But Dr. Patel did that. On page 9 of his report, in the section entitled Opinions, he states the patient's MRI findings did not demonstrate findings consistent with acute trauma and with a diagnosis of a sprained strain. Formal treatment for the patient's mostly axial neck and low back pain after the MVC was not necessary. A sprained strain is a self-resolving condition that does not require formal treatment and will resolve with home stretching exercises and oral anti-inflammatories. Epidural injections are not necessary, much less an evaluation with a pain management physician. Now, I find Ms. Rivas's argument to be a bit circular, in that she states that Dr. Patel is not qualified to give his opinion, and then she says that she looked on his website and he provides the same type of services at his clinic as those that were allegedly required by the plaintiff in this case. Which is it? Either he's qualified to provide those practices or he's not. So that's kind of where we're coming from, especially with regard to the surgery at Momentum Spine and Joint.
Yes, to that point, if I may, just like at Momentum Spine and Joint, there's surgeons that practice there and there's pain management doctors that practice there, both who perform different types of services. I think that might be the case going on at Dr. Patel's clinic. He's a surgeon, he performs the surgeries and the surgery recommendations, and there's other doctors that are there. I was just saying that point goes to how highly unreliable his opinions are, because how he practices or how his clinic practices medicine is completely different and opposite than what he's saying was necessary in this case. For him to say that, 3.5 millimeter herniation is going to go away on a 30-year-old, yet her double board certified surgeon in this case went through with the surgery, made the recommendation. I just think that's, and it contradicts, what his practice, follows. So I just think that.
Ms. Rivas, let me just say this. So we have a couple options here. Ms. Glenn has obviously listened to me, which makes her a very good lawyer in other hearings, because I just had a hearing less than an hour ago where I struck a counter affidavit from a billing records clerk saying that they're not qualified. I do think Dr. Patel is qualified to be a counter affiant. The question is this a sufficient affidavit? I apologize. I need to take a very quick. Sorry about that. So, we can look a little bit more detail that he did discuss Medicare, Medicaid, which I think Medicare and workers' comp. And I would definitely strike that portion of the counter affidavit because I don't think it's relevant. But One option would be if you guys agreed, we could do this as dueling affidavits, which I'm sure you've dealt with before. Or I could just make a decision on the merits on whether or not to strike this counter affidavit. What do you guys prefer?
I would prefer you make a decision on the merits, Your Honor.
All right, I'm going to go ahead and for Dr. Patel, I'm going to go ahead and deny the motion to strike. So let's talk about the pharmacist.
Okay, so the pharmacist is Ricky Merritt. He gave, I think, a 2-page counter affidavit. Very basic. He said, based on my knowledge, skill, experience, training, like I'm sure you've heard, he opined the pharmacy charges were unreasonable. He didn't even try to give Medicare or Medicaid as a basis. There literally was no basis at all in his counter affidavit.
I've never seen a pharmacist try to do this. This is interesting. Okay, go ahead, Ms. Glenn.
Well, obviously, I disagree with Ms. Rivas. I did outline on page 8 of our response his basis for determining that the costs were excessive is based on the usual customary reasonable amount routinely charged by other pharmacies to uninsured self-payers on the date where the medications and pharmaceutical products were provided. It's basically like to like, as I know you prefer, Judge Hoffman, a pharmacist to a pharmacist, saying that in his education, training, and experience, and comparing the customary and usual amounts in the area, the amounts were excessive. So that's what's required, and that's what Mr. Merritt did.
And
I will give you the same opportunity, and I would highly, I mean, I haven't, let me see. I would highly recommend you agree to do a counter affidavit as the pharmacist. You don't have to call the pharmacist live.
you mean joint affidavits?
Doing affidavits as the pharmacist. I would suggest both of you guys agree to that.
Well, I will take your suggestion, Your Honor. I'm listening.
Ms. Glenn, will you agree to that as well?
I will agree to that, Your Honor.
All right, so dueling affidavit, just so it's clear, is the plaintiff will be able to present the affidavit of the billing record affidavit as the pharmacy. That'll be sufficient to show reasonable necessity paid and incurred for trial, but Ms. Glenn and her client will be able to submit the counter affidavit and argue that at trial as evidence, which you usually can't do. We're not ruling on in this case, on whether or not the pharmacist can testify as an expert. That's not what a counter affidavit does. So
Yes, Your Honor.
does that comply with both of
Did
your
you mention something about striking the Medicare portion of Dr. Patel's?
Well, no, since it doesn't matter at this point because you didn't do you didn't agree to a dueling affidavit. So that means you'll have to call the doctor live.
Okay.
And Ms. Rivas, you appear in my court a lot. Just be aware that when I give you that suggestion, that's kind of a hint of what I'm going to do. So
we've got these doctors to testify already. We've done their depositions, but I understand.
You already have depositions, so that it's not a big
Yes.
deal. All right, so Ms. Glenn, if you could go ahead and prepare an order for us on this.
Okay, I submitted one, but I need to revise it for Mr. Merritt.
Sounds good.
Okay.
All right, I think we are done with this hearing. You guys be safe, okay?
Thank you, Your Honor.
You
Oh, Ms.
too.
Woods, did you want to? I'm sorry, Ms. Woods, did you want to say anything?
I don't.
Okay.
For once.
Well, you were here early and had to wait through all of this, so I didn't want to keep you from speaking. If you
No.
didn't. Okay.
Thank you, Your Honor.
You guys be safe. You have a great day. Okay.
Thank you.
You too.
You too, Your Honor.
Bye-bye.
Bye.
Hey, Samantha, did you text me last night or was that Peyton about a doctor's appointment?
It wasn't me, so it was probably
Okay.
Peyton.
For some reason, I thought I'd saved her phone number and it didn't come up on my phone, so I don't know. I have a new iPhone and it's doing weird stuff, so.
Judge, just to remind you again,
I'm
sorry to
still
cut you
on